Hello, my name is Justin Sterling. I am an attorney and I am the founder of the Sterling Firm. We're talking about what is copyright. If you are a creative artist or you are involved in the creative community, you need to know the basics of copyright law. Just as a brief history, the word copyright essentially means the right to copy. Originally, copyright was a right only held by authors and it only covered copying. Copyright was developed from the U.S. Constitution, which states that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The key phrase here is the exclusive right. Congress immediately passed the copyright law in 1790, which gave authors the absolute monopoly over who could make a copy of their creations in order to encourage them to create new works. Originally, copyright only lasted for a period of 14 years with an option to extend the right for another 14 years. Copyright today, copyright protection has expanded. Copyright law now gives authors a monopoly over much more than mere copying of their works. The exclusive rights of a copyright owner has expanded and evolved due to modern day advances. Today, copyright protection lasts for much longer than 14 years. Also today, the categories of works that are covered by copyright protections has expanded more than the original list of just maps, charts, and books. Who is the copyright owner? Okay. Copyright law states that the creator of a work is its author. This is true. However, there are exceptions. The first exception is employment relationships. If the creator is an employee working within the course and scope of employment, then the employer is considered the author of the creative work. The second exception is a work-for-hire relationship. If the creator is not an employee, but is an independent contractor or an independent person commissioned to write a script or create another category of creative work, and there exists a signed written agreement between the parties expressly stating that the work is a work for hire, then the author is the person or company who paid for the work to be done. There is a narrow list of works pursuant to copyright law that may be considered to be work for hire. These are 1. A contribution to a collective work. 2. Part of a motion picture or other audio-visual work. 3. A translation. 4. A compilation. 5. An instructional text. 6. A test. 7. Answer material for a test. 8. An atlas. And number 9. A supplementary work. The concept of work for hire was developed as a result of the motion picture industry. In the early 1900s, the early film entrepreneurs and movie moguls realized that they had to lobby for legal protection because there were so many creative components involved in the production of a film. Okay, copyright protection adheres at the moment of creation. Okay, the moment that a creation takes on a tangible form, copyright adheres in the work. Prior to 1978, the work had to be registered with the Copyright Office and it had to have a notice of copyright in order for it to be protected. This has since changed. The law has evolved. Copyright protection attaches automatically and immediately once a work is created and expressed in a tangible form. Copyright does not protect ideas though. Copyright protects the embodiment of those ideas in a tangible medium. Once a creative idea is expressed in a tangible form, the creator has a monopoly over the uses of the work and has exclusive rights to that work. It is important to note that it is strongly encouraged that you registered your work for copyright protection with the U.S. Copyright Office. Even though it adheres at the moment of creation, still register your work. Registration grants federal court jurisdiction in the case of copyright infringement, and it also grants certain presumptions to the copyright owner. Federal court jurisdiction also allows for special remedies such as an injunctive relief and statutory damages in the case of a copyright infringement action. Statutory damages of up to $150,000 for willful infringement. Okay, how long does copyright protection last? Today, copyright protection lasts for the life of the author plus 70 years. Now, if the author is a corporation because the work is created in an employment relationship or because of a work for hire agreement, then the copyright protection lasts the shorter of 95 years from the day the work was published or 120 years from the day it was created. A work is published if it is presented to the public, no matter if it's for charity or for profit. Okay, the exclusive rights of a copyright owner. Copyright protection grants to the owner certain exclusive rights. If any other person wants these rights, that person must get the permission of the copyright owner. There are 4 main rights that come into play. 1, the right to make copies. 2, the right to prepare derivative work. 3, the right to distribute the work. And 4, the right to publicly perform the work. 1, the right to make copies. Even making a single copy of a protected work is a violation of copyright law. There are exceptions, however, the biggest being the fair use exception. However, the core of copyright law still is the exclusive right of the copyright owner to make copies of his or her own work. In order to make a copy, a person must get the permission of the copyright owner. 2, the right to prepare a derivative work. A derivative work is a modification or an alteration of an already existing work. Copyright law protects original works of authorship. For example, a derivative work can be a movie that is made from a script, a book, or another movie, or even a derivative work can be a knockoff painting. In order to modify a work, permission from the copyright owner is required. 3, the right to distribute the work. Distribution occurs when you make the copyrighted work available to the public. Now, this can be done through selling the work, transferring of ownership, or even licensing. If someone wants to distribute a copyrighted work to the public, that person must get the permission of the copyright owner. 4, the right to publicly perform the work. Every time a movie is played in the theaters, aired on Netflix, or a song is played at a concert, that is a public performance of a work. The test for whether a work is being publicly performed is whether the public is invited. This is regardless of whether a fee is being charged or if it is for charity or if it's for free. In order to perform a work to the public, permission is required, again, from the copyright owner. There's also 2 other exclusive rights that are important to note. 1, the right to publicly display a work, which involves images. And 2, the right to digital audio transmission of sound recordings. Okay, now the types of creations expressed in intangible medium that are protected by copyright include books, plays, songs, musical compositions, music recordings, even if the music is itself part of the public domain, photographs, paintings, scriptures, jewelry, even choreography today, computer programs, and of course movie scripts, treatments for scripts, and translations. Okay, now that we've covered the basics of copyright, including its history, its powers, and its protections, you can confidently start creating works and distributing them to the public with an essential knowledge of what factors to keep in mind when considering if your projects are being used and enjoyed fairly. Keep in mind that this is only the tip of the iceberg when it comes to the universe of copyright law. So stay tuned for more useful information. If you like this video, please feel free to comment, subscribe, or leave us a thumbs up on our YouTube channel, and please feel free to forward this video to any friends or family members. If you have any further questions about the basics of copyright law, I encourage you to contact the Sterling firm at 310-498-2750 or send us an email at info@thesterlingfirm.com. Now, I hope you enjoyed this video and have a wonderful day. Thank you.